The next case and the last case today is Logan versus the City of Southgate. It's a 15-minute mini oral argument on the application. Mr. Hicks, that means you may try and reserve some of your time.
Thank you. May it please the court, Steve Hicks on behalf of plaintiff appellant Donna Logan. Time permitting, I would like to reserve 2 minutes. The court's asked us two questions today. The first question is whether the duty under the statute that governs public sidewalks was abrogated by the addition of the common law open and obvious defense. The second question is whether the trial court erred by concluding that the condition in this case, a 5-inch defect in sidewalk slabs, was unreasonably dangerous. The first question presents, of course, what appears to be a question of statutory interpretation. I would note at the outset it's a somewhat odd question of statutory interpretation because the statute that we're dealing with explicitly references the common law. So there has to be an understanding of what the common law is that would inform that statute. The second question addresses specifically what is the common law open obvious defense in Michigan under Lugo. I would just note that with regard to both of those questions, I feel like I'm in a bit of an odd situation today arguing this because, as the court knows, there are two premises cases that are going to be heard, one of which is my case, Pinsky versus Kroger, that address some of those issues of how the common law open and obvious defense works. So that being said, I'd like to focus on this particular statute and the duty that was created. And I'd like to focus on that primarily, and then I'll be happy to address any questions that have to do with whether this was an unreasonably dangerous condition under existing law or the law as I would envision it. With regard to the duty for municipalities to maintain in reasonable repairs public sidewalks, I think the defense is remiss in focusing singularly on 691.1402A. This provision's been around a long time. It's been around longer than the adoption of that provision. 691.1402 sub 1, we typically call this the highway exception, and it does apply to highways. Whereas was the spot where the legislature said in adopting the Governmental Tort Liability Act, they said that the municipalities, or government agencies, excuse me, shall have a duty to maintain the highway in reasonable repair. Why does that matter? It matters because they defined highway to include sidewalks. So before we ever had 1402A, we had this statute. And the fact is, they never got rid of 1402. 1402 is important in two respects. First of all, it tells us what that duty is, maintain in reasonable repair, which is the language that they used in 1402A. But it also tells us why they're doing it. They're doing it so that the highways, which include sidewalks, shall be in a condition safe and convenient for public travel. And I think the defense is remiss in not recognizing those important words. It's supposed to be safe and convenient for public travel. Now, admittedly, this court in Naraki, which dealt with the highway exception, said that, well, that doesn't create any new duty, but it expresses the legislative intent and what the desired outcome was in creating a duty to maintain in reasonable repair. So I wanted to start my remarks by focusing on 1402 because I think it's important to not overlook that section. Now let me shift to 1402A, which I think is really where the court's questions probably are. As I said, the duty under 1402A is the same as 1402 in that it says that municipalities need to maintain sidewalks in reasonable repair. The statute is very specific with regard to sidewalks. It has a number of sections. It creates a notice provision, but most importantly, it also creates a presumption that anything under 2 inches, there's going to be a presumption that there is no negligence. So anything under 2 inches is going to be presumed to be okay. There's not going to be liability in that context. And in creating that presumption, they didn't just say that. They didn't just say that there's this 2-inch rule that creates a presumption. They also said, and that's going to be a legal issue for the court to decide. So they were very specific in creating that rule and that presumption. Why is that important? Because the 2-inch rule actually was a common law rule as well. That's where it came from initially. And when they adopted it into statute, they made very clear how this was going to apply. I point that out because of what I'm going to say about the defense that we're dealing with here today. In the section that talks about the common law open and obvious being used. And there I'm referring to 691-1402A, it's sub 5. What did the court do in 2016 when they adopted this common law open and obvious defense? First of all, I think there's a couple quick points to make about the wording that they used. What they said is that the municipality may assert, in addition to any other defense available to it, any defense available under the common law, including but not limited to a defense that the condition was open and obvious. They talked about the municipality asserting a defense. Nowhere in that provision did they say a single word about duty. And that's a fundamental distinction between this statute and the common law under Lugo, which said that duty isn't, the open and obvious is an integral part of duty. That's what's lacking here. There isn't any discussion of duty. There's not any attempt to incorporate Lugo into law. They basically just said, you can assert a defense of common law of open and obvious. So they basically left it up to this court to give meaning to that. And I just point out that's quite a contrast from the way they framed this other common law was a defense, the 2-inch rule, when they adopted it into statute. I read that as being what it says, which is a defense that they may assert. Now, the defense will say, well, that means that everything that was said in Lugo is law, that the legislature's intent was to change the duty to make open and obvious an integral part of this duty as well, this duty to maintain and in reasonable repair public sidewalks. The language doesn't say that, and I pointed out that it's just lacking in that regard. But I think it's important to understand the distinction between the two duties. This is actually a pretty limited duty under 1402A. It is merely a duty to maintain in reasonable repair. In the highway context, the court has pointed out that maintaining in reasonable repair doesn't cover a design defect. It doesn't cover traffic signals. So it's very limited, whereas the duty in the common law, under the common law in a premises case, is broader. It's a duty to protect from an unreasonable risk of harm. It can include duties to warn. It can include duties to inspect the premises. It's a broader duty when it applies. So I think to say that, well, clearly what the legislature was saying and saying that municipalities can assert the open and obvious defense, they were saying you get exactly the defense that's asserted in Lugo. Fundamentally, I think that's wrong because nowhere, and no court has ever said that it is an integral part of this duty, and that's the key thing. So what do they get? Clearly the legislature was doing something. You know, they weren't just adding this in there for no reason at all. What were they trying to do? They were trying to reverse a particular line of cases. Jones versus Entertel is an example of those cases that said you can't defend on open and obvious grounds in cases that involve this statutory duty. That's not going to be your defense in these cases. And the legislature's intent in adopting this statute was to say otherwise, was to say, no, they can assert that defense. What does that get them if it doesn't get them summary disposition? I suspect defense counsel will argue. Well, it gets them quite a bit. It gets them a definition of open and obvious. That isn't really in play in this case because open and obvious was conceded. I mean, we have a Coke can sized high defect here. It's not a small defect. But they get that definition. And what is that? Basically it focuses on an average user discovering the condition upon casual inspection. It gives some meat to that they can use. It also makes it very clear that this is an objective test that's going to be applied. And the fact that you may be, let's say, a person with a disability trying to navigate that sidewalk, in the premises context, that hasn't proven to matter. So they do gain that here. In addition to that, you would be working under the Lugo framework to the extent that if you have an open obvious condition, as was conceded in this case, you would have to show special aspects to move forward. And special aspects under Lugo, assuming Lugo is the applicable law, are defined as, is it effectively unavoidable? I don't think that really have any application here. In fact, I have trouble conceiving of a situation, given the court's holdings on effectively unavoidable, when using a public sidewalk would fit that definition. I guess maybe if a public sidewalk led right to your place of business, potentially, but typically sidewalks, and as defined in this statute, it's sidewalks that run adjacent to the street. There may be some other sidewalk you walk up to go to your business, but that's really not germane to this analysis. So effectively unavoidable is sort of a special aspect that has no real application in the context of public sidewalks. So what is the other special aspect that the court looks at under Lugo? And now I'm here kind of segueing into the second argument about unreasonably dangerous. In Lugo, the court said there can be a special aspect. There could still be an unreasonably dangerous condition if the condition poses a uniquely high likelihood of harm or severity of harm. And that's a direct quote. And in my mind, and I don't know that this has been argued in a case, certainly not one that has gone to this court, that provision or that special aspect analysis, uniquely high likelihood of harm or severity of harm, really goes to two things. It goes to the potential for harm, likelihood, and degree of harm, severity of harm. So there's really two ways to satisfy that element of special aspects, although there's never been much analysis on that. I think it's important in this case, in particular because of likelihood of harm. Sidewalks are intended to be used. People are going to use them. They need to traverse them to get to places of business. They need to traverse them to get to, in this case, my client was going to a friend's home. They're intended to be used. That's why the statute says make them safe and convenient for public travel. That's why that is the intended goal. And where the analysis breaks down in this case is that Lugo has morphed over the years. I think defense counsel has correctly cited in their brief where we are on the Lugo standard. And their argument is, and there are cases from the Court of Appeals to support them, that unless it shows an extremely high risk of severe harm, and that's the quote, extremely high risk of severe harm, then it's not going to be actionable if it's open and obvious. That's quite a different standard from what the court actually said in Lugo. Now, as a caveat, I would say they didn't create that a whole cloth. It is a quote from Lugo in a footnote in which the majority was responding to Justice Weaver's concerns that, hey, why are we focusing on severity of harm? We've never done that before. It's never been the focus. And the court was responding and saying, are you saying we shouldn't consider severity of harm if there was an extremely high risk of severe harm? Why shouldn't we consider that in saying this still matters? This fact that it's open and obvious is not good enough. So they were responding to that concern. So where did the court go wrong? It was really in Hoffner versus Langto, a subsequent case, where that was just quoted, that The test is effectively unavoidable or extremely high risk of severe harm. Problem is, in Hoffner, that wasn't the issue in the case. Hoffner was an effectively unavoidable case, like Livings and like Kandahar said. So that's where the court went off base. So I heard the buzzer. I know I've gone on for a while.
The clock ran out.
If you have any questions, I'd be happy to answer them, but I realize I've exhausted my time.
Thank you, counsel.
All right, thank you.
Good afternoon, Chief Justice and Justices. When I was reading the plaintiff's briefs, I tried to crystallize the argument, particularly on issue 1, and isolate what it really is. And I think I did. I found 2 sentences that I think crystallize it, and I'd like to read them. The first one was from page 9. It says, if the common law open and obvious defense is applied in its current form to public sidewalk defect claims, it will abrogate the statutory duty to maintain public sidewalks in reasonable repair under subsection A1. And then, that's true. I mean, we agree with that. And on page 2, it says, the legislature did not intend to abrogate the statutory duty to maintain sidewalks by adding open and obvious as a defense to such claims because it would not be consistent with the comparative negligence laws that the legislature adopted. Now, our position is that comparative negligence has nothing to do with this issue. It never has anything to do. It never has had anything to do with the issue of open and obvious because, as was pointed out, there's a lot of case law that says that it's an integral part of duty. And that's the way it's been treated all along. And that's what the legislature was dealing with in 2015 and 2016 when it was discussing this subsection A5. Now, I know that, as was also mentioned, there are, I think, 3 cases now before the court. You're thinking of, maybe overhauling the whole issue. I have no idea. But there's the Kandil El Sayed case, the Pinsky case, Becker case, and at last count that I had, there were 6 other cases that the court has taken, held in abeyance, pending its decision in those cases. But I want to emphasize that this case has to do, it doesn't concern that issue. This case concerns what the legislature intended back in 2015 and 2016 when it enacted Section A5. And that no one had any doubt that at that time and to this day, open and obvious has to do with the issue of duty. And so how could the legislature in 2015 and 2016 have intended for the doctrine to be applied as a matter of comparative negligence?
So counsel, based on that, I'd like to engage you if I could. Because I realize there's a number of things here, and I realize, as you said, you're absolutely right. There's a litany of cases dealing with the doctrine. So I'm going to basically kind of give you the first crack at it as it pertains to the question I'm going to pose to you as it pertains to the open and obvious doctrine. Let's just take the facts of this case. This sidewalk had been in disrepair for 4 years, correct?
Well, the issue of notice, and that really hasn't come up.
No, I understand, but we're talking about the doctrine because you brought up the other cases and the issue of open and obvious. So I'm kind of, taking kind of the first step in that direction, asking you these questions as it pertains to the doctrine. So in this situation, you had a sidewalk that was, in this case, was in disrepair, and the city allowed for that sidewalk to be in disrepair for over 4 years. Is that correct?
I will assume that to be true because that issue has not been litigated and it hasn't come up, and it didn't come up in this motion.
I understand.
The 2-inch rule didn't come up. It didn't have to because we know at one point it was over, and the notice issue didn't come up.
No, I understand, but we're talking about open and obvious. We're talking about the doctrine.
Right.
And so, which is what we are kind of here talking about. And again, I understand there's some specificities as it pertains to this case,
Uh-huh.
but I'm focusing you in now on the issue and the doctrine of open and obvious as it pertains to Lugo. And the question I'm going to ask you, and I realize it's going to be a difficult question, so I just want you to do the best you can with it, right? But it's a question that, needs to be asked, and a question I'm going to pose to you. And it's going to be a question that I will be posing to others, but it's the question I'm going to start by posing it to you. I'd like you to answer it to the best of your ability, because I realize it's going to be a challenging question. I'd like you to answer for me, how does the doctrine of open and obvious apply to a person who is blind?
Well, that was the Chicken Shack case. I think it was the Chicken Shack case, where it was, as I recall, held that the doctrine does apply because it's an objective standard, and you look at this,
Right, no, I understand.
And that's my understanding of, I can't tell, it comes down to maybe a policy issue, I don't know.
Right. But I guess my question to you, since the court is getting into this issue, is, and just do the best that you can with it, right? I'm just kind of posing the question, and this question's going to be coming up again. But the question that I'm going to pose to you is, does that make sense?
It depends, I think, on which side of the policy issue you're
No, I'm
falling
asking
on.
you just logically. Does it make sense? Can a blind person appreciate conceptually? I understand what Chicken Shack says. I'm asking you.
Well,
Does
of
it
course,
make
a
sense
blind person can't
conceptually that a blind
perceive-
person can appreciate
yeah,
the notion of what it means for something to be open and obvious?
There's no way to answer that except to say the obvious, which is a blind person cannot perceive things that others can. The courts and apparently the legislature have decided to take an objective view instead of a subjective view because of reasons that I can't articulate at this moment, and I'm not prepared to.
No, and you've done a
That's
very
really not an issue in this case.
No, I understand. You've done a really good job, and I'm going to ask you one more question.
Yeah.
The ADA, how does the ADA, because in terms of this specific issue, you had a sidewalk that was in disrepair for 4 years, and we're getting into the issue of unavoidability and all those types of things. How does the ADA play into this?
Well, it's my understanding that under the analysis of open and obvious danger, violations of codes and administrative rules and things like this are not dispositive because the fact that something is in violation of such a rule doesn't make it any less obvious.
I understand.
It's
but
still-
how
it's still-
does a wheelchair get around this?
Well,
You have a
you don't
large
have,
incline.
I don't know, if you see it, you don't confront it, or you make a choice to confront it or not, or you make a choice to have someone with you or not, I don't know. But it is my understanding that violations of, as I said, codes and things like this, administrative bodies, or administrative rules, don't make things less obvious. Yes, they're violations, but it doesn't make it less obvious.
Counsel, you've done a very good job with these questions. I realize they're difficult. I realize they're challenging. You've done an excellent job. Please proceed.
Mr. Schaefer, can
Thank
I
you.
ask you a question?
Yes.
I'm wondering, as you and your opposing counsel both pointed out, there are a number of cases dealing with open and obvious that the court has agreed to hear.
Right.
And is looking at that.
Right.
Is it your position that, based on the language utilized by the legislature in sub 5, that if the common law were to change or, be further explained or what have you, that the availability of that would impact subsection 5, or is it your position that you think that the common law defense of open and obvious that applies to a sidewalk case would sort of be frozen in time
Right.
with the state of the law at the time that the statute was amended?
Right. I was thinking of that issue driving here. Because that
See,
that
that's why I
issue,
knew, and that's why I asked you.
we were communicating.
Yes. Yeah.
That issue has not come up in this case. But I thought that is interesting. But, to cut to the chase, in this case, it makes no difference. Because in this case, we know what the law was in 2015 and 2016. And that's why I said at the beginning, really, the cases that are pending now before the court in which the open and obvious doctrine may be turned on its head, I have no idea, really don't affect this case. Because we're looking at what the legislature intended under the doctrine as it existed in the common law in 2015. And we all know what it provided at that time, and it still provides to this time. It's really kind of unchanged with, living's kind of changed a little bit recently. But it could be that there is a kind of an earthquake that's erupting in the area of open and obvious danger. I mean, we all know this. Something is going to happen. But my point is, in this case, it's irrelevant, And as for what the legislature intended, whether it intended for open and obvious in the common law to remain fixed in time forever under A5, while, as a matter of fact, over here, we have the common law evolving, and changing from what it was in 2015, whether that new law will now apply under A5 or whether, as you say, it was fixed in, well, that's an issue for another case. I mean, that's a really good issue. I don't know what the answer to that one is. Legislative intent, I mean, I don't know. But as I said, to kind of narrow it down in this case, I don't think it's dispositive.
Counsel, I'm wondering, as you understand the law, and as you're saying the law should apply to this case, can a plaintiff ever make it past this statute on a sidewalk differential case?
Almost never.
And you think that was the intent of the legislature? I mean,
Exactly.
they could have just said,
Exactly.
no sidewalk lawsuits. They could have said that.
They could have said that, but I think I quoted this in my briefs, and when the matter was being debated and there were legislative analyses and other things produced, one of the things that was noted in the legislative analysis, and this is attached, I filed this, the legislature, the legislators knew this. I mean, they were well cognizant of this, what you're talking about at the time that it was debated. And one indication of that is that in the legislative analysis, it says under against, persons who are against the proposed amendment, that opponents argue that House Bill 4686 would, for all practical purposes, make municipalities completely immune from lawsuits made by people injured by defective sidewalks. They knew that was a possibility and apparently agreed with it. And in any case, what they did agree with is that cities should be treated no less than private owners who can take advantage of the open and obvious doctrine. I think the whole intent behind this subsection A5 was to put private landowner defendants and public city defendants on the same footing, so to speak, in terms of availability of the doctrine of open and obvious danger. And in the private premises liability context, it's also almost impossible, and that's why there have been, we've all seen them. I've been practicing law for 40 years, 41 actually, and the number of premises cases and slips and falls have, gone down, and I think it's a direct correlation of the adoption of the open and obvious danger doctrine. So this is not doing something for the cities that has not already been done for everybody else. That would be my response to that. Also, I wanted to emphasize one thing. In my brief, I did note that when the issue of interjecting comparative negligence into A5 was made by a senator, State Senator Stephen Bida. He proposed an amendment to make the issue under Section A5 a matter of comparative fault and not a matter of duty. That was rejected. And I pointed that out in my brief, but what I didn't point out in my brief was the same exact amendment was also put forward in the House by State Representative Jerry Moss. I think he's a senator now. And that amendment there was also rejected. So, you know, they did consider doing what the plaintiff has suggested here, and it was rejected on 2 occasions. I hear the bell. Thank you very much.
Thank you, counsel. We used up all your time at the beginning. Sorry, the case will be submitted. That concludes today's call.